live session for the contracts course. My name is Catherine Dove. I'm your instructor, and this meeting is being recorded from the benefit of your classmates who are not here, and in case you would like to watch it again yourself. So what's going on in Module 2? Let's see. Defend a statement of consideration, create an intake form based on a written scenario or a legal case, rewrite contract terms based on an intake form, correct defective terms using an intake form, research possible remedies for breach of a business contract situation. So that's what's happening in Module 2, and we will talk about some of that during this live session. So here are your assignments, reading chapters 3 and chapter 12. Chapter 12 is most important because it covers the Uniform Commercial Code, which applies specifically to contracts for the sale of goods and has special remedies for sellers and buyers in those circumstances. The restatement of contracts is simply like an encyclopedia or a treatise about contracts. It's suggesting that you read chapter 4, and then remedies, the Uniform Commercial Code, Article 2. Article 2 of the UCC applies to contracts for the sale of goods. We will be talking about the remedies provisions in the UCC Article 2 tonight. So what is the Uniform Commercial Code? Well, hi, Stephanie. We're just getting started. The UCC is a special set of rules that apply to contracts for the sale of goods. You know, we live in a world now where goods flow freely through the stream of commerce. And along with that, we have all sorts of e-transactions taking place. We're going to get more into that, you know, in further modules. With the complexity of shipment, the ease of travel, the business deals that are being done across international lines and across state lines, there was a recognition within the legal community that we needed a uniform commercial code. So every state has adopted some part of the UCC and codified it in their own state statutes. Some contracts will actually tell you in writing, hey, this contract is subject to the Uniform Commercial Code. So again, the UCC has special rules for what contract remedy is available in the event of a breach. We're going to be looking at that. So buyers and sellers remedies, this is presented in chapter 12. Usually the parties to a sales or lease contract owe a duty to perform the obligations specified in their agreement. So once a contract is formed, each party has a set of obligations. If it is a contract for the sale of goods, say that the seller is selling 10,000 nails to the general contractor on a construction site, the seller has obligations and the buyer has obligations. Those are spelled out in their agreement, and they're also spelled out in the UCC section 2-301. 2A refers to lease contracts. An example of a lease contract might be somebody going and leasing like a really fancy rider mower, or if you lease a car, certain contracts for the lease of goods as opposed to the purchase would be governed by UCC Article 2A. We will mostly be talking about Article 2. So the seller's general obligation is to transfer and deliver the goods to the buyer. Makes sense? It's a sales contract. Each party has promised to do something. Jody, what does the buyer in a sales contract promise to do?
The buyer, you mean?
Yes.
They're obligated to make purchases. That's the consideration, the money. Am I correct on that?
You're exactly right. The seller promises to deliver, the buyer promises to pay. It's very simple. In a contract for the sale of goods, those are the obligations. The seller's obligation is to transfer and deliver conforming goods to the buyer. The buyer's obligation is to accept the goods and pay for them. Now, when one party breaches that sale contract, the Uniform Commercial Code provides the injured party with a variety of pre-litigation, that's before you file a lawsuit, and litigation, if you have to file a lawsuit, additional remedies. These remedies are designed to place the injured party in as good of a position as if the breaching party's contractual obligations were fully performed. UCC Rule 1-106. So you should go back after the live session and read these provisions of the UCC. Read 1-106. So the whole point of contract remedies are to put the non-breaching party back in the same position they would have been if everyone had performed their promises, right? Promises are important, and a contract is a set of legally enforceable promises. So if one party doesn't keep their promise, they can be sued for damages. Now, the best remedy is going to depend on the circumstances of the particular case. The performance of obligations and remedies available for breach of sales contracts, again, are discussed in detail in Chapter 12. So let's get back to the seller's obligation to perform. Tender is a legal term under the UCC. Tender of delivery is a transfer and delivery of goods to the buyer in accordance with the sales contract, and it's one of the seller's basic obligations in UCC 2-301. Tender requires the seller to put and hold conforming goods at the buyer's disposition and give the buyer any notification reasonably necessary to allow delivery of the goods. The parties may agree to the time, place, and manner of delivery. Now, if the seller delivers non-conforming goods, it happens sometimes. There could be a mistake. Somebody in the warehouse could send the wrong box. Well, the UCC says that the seller does have an opportunity to cure. Adrian, why do you think the UCC allows the seller an opportunity to cure the delivery of non-conforming goods?
Well, I think maybe, like you said, there could be a mistake. Or if it's being delivered, it may, once it's out of their hands, something may happen in between. Something, let's say it's glass and it could break, and then that's really not their fault. So they have that opportunity to cure, as they say, to make up for it.
Good. And, in a society like ours, a society based on capitalism and commerce, we want to do everything we can to encourage commerce. So we do not want the contract to fail because of an accident, because someone delivers non-conforming goods when they actually still have the conforming goods at the warehouse. So to uphold that contract would serve the best interests of the commercial transaction, and the best interest of capitalism is to keep that free flow of commerce and to encourage parties to contract and to enforce the contract. So it is in the best interest of everyone to give the seller an opportunity to cure by replacing the defective or non-conforming goods. And that's UCC 2-508. A cure may be attempted if the time for performance has not expired and the seller notifies the buyer of his or her intention to make a conforming delivery within the contract time. So there's no time limit in the UCC. It just has to be within the time specified by the contract. What does the buyer have to do? Well, once the seller has proper tendered delivery, the buyer is obligated to accept and pay for the goods in accordance with the contract. If there's no agreement, the UCC controls. And if there is an agreement, the UCC controls. So the UCC controls either way. Of course, if there are contractual terms, those would apply, in addition to the UCC, which applies to every contract for the sale of goods. Well, the buyer has a right to inspect. The buyer has the right to open up the box, look at the goods that have been tendered or identified in the sales contract prior to paying for them. I mean, that seems reasonable. Somebody delivers a box, you have the right to open it up and see what's inside of it. So if the goods are shipped, the inspection may take place after their arrival. If the inspected goods do not conform, the buyer can reject them without paying. That's UCC 2-513. If the inspected goods do not conform to the contract, the buyer can reject them without paying, because they're not getting what they bargained for. You know, if I bargained for the delivery of a 2022 Ford Mustang GT in blue, and the dealer sends over a black convertible, I don't want a black convertible. I want a blue hardtop. That's non-conforming goods. UCC would apply to that. And I would have the right to reject that and not pay for it. You know, this isn't what I asked for. Payment. If the goods are accepted, the buyer must pay for them under UCC 2-607. Unless the parties to a contract agree otherwise, payment is due from a buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. Sometimes the place of delivery might be the seller's warehouse. The contract may specify that the buyer send an employee to the seller's warehouse. The warehouse doors are opened up, and that's the place of shipment and delivery. Payment would be due right then and there, unless the contract says otherwise. Buyers often purchase goods on credit extended by the seller. Unless the parties agree to other terms, the credit period begins to run from the time the goods are shipped, not the time they're received. The credit period runs from the time the goods are shipped. A lessee must pay the lease in accordance with the lease contract. Okay, another remedy the buyer has is the revocation of acceptance. A buyer who accepts good may subsequently revoke her acceptance if the goods are non-conforming. The non-conformity substantially impairs the value of the goods, and one of the following is shown. The seller's promise to timely cure the non-conformity is not met. The goods were accepted before the nonconformity was discovered, and the nonconformity was difficult to discover. You know, the buyer just accepts this box, pays for it, and then later on opens up the box and realizes everything in it's broken. The goods were accepted before the nonconformity was discovered, and the seller assured the buyee that the goods were conforming. So the buyer does have the ability to revoke acceptance. Okay, what are the seller's remedies under the UCC? Well, the seller can withhold delivery. Delivery of goods may be withheld if the seller is in possession of them when the buyer breaches the contract. So if you have an installment contract or a supply contract, maybe the seller is selling gasoline to a convenience store, and the seller comes, you know, the trucks come every so often and they load up the gasoline. Well, if the buyer hasn't paid for the shipment of gasoline in January, what can the seller do in February, Jody? The buyer has not paid for the shipment of gas that was delivered in January. What can the seller do in February?
I'm trying, sorry, I was trying to unmute myself. The seller there's a remedies where they can go after a legal action of recovering the money, though.
Okay.
Yeah.
What else? What about future shipments? If this is a
They could they can stop future shipments on a certain product. I've seen that happen before. I used to work
Good.
at a retail store, so I saw future shipments stop.
Yes. Good, Jody. Yeah. If the seller and the buyer have a long-standing relationship and it's what's called a requirements contract or an outputs contract, where the seller routinely provides goods, once a month in a certain quantity. And if the buyer, gets the goods delivered in January, doesn't pay for them, the seller does not have to keep supplying that buyer who's breaching the contract. They can withhold the goods. The remedy is available if the buyer wrongfully rejects or revokes acceptance, fails to make a payment when it's due, or repudiates the contract. Repudiation is one party telling the other one, you know what, when the payment is due in May, I'm not going to be making it because we're going out of business. We're insolvent. That'd be what's called anticipatory repudiation. So if one party acts in a way so as to repudiate the contract, act like the contract does not exist, the other party doesn't have to perform. So if part of the goods under the contract have been delivered, when the buyer materially breached, the seller may withhold delivery of the remainder. UCC 2-703. That makes sense. Part of the goods have been delivered, buyer doesn't pay for them. Well, the seller doesn't have to ship anymore. The seller who discovers the buyer is insolvent before the goods are delivered may refuse to deliver unless the buyer is going to do COD, cash on delivery. 2-702. Any questions so far about these UCC remedies? Great. You will have a quiz in Module 3 on some of this information, so you will need to know it. Fortunately, though, we will have a quiz review next week so that you're prepared for the quiz, but you will need to know the UCC remedies. Let's talk about the buyer's remedies. The UCC provides a variety of remedies to buyers if the seller breaches. One is the right to reject non-conforming goods or improperly tendered goods delivered to the wrong place. The right to recover the goods from an insolvent seller. The right to obtain specific performance. In order to get specific performance, you have to go to court, you have to sue for breach of contract, and you have to ask for the remedy of specific performance. Well, why does that matter? If you were purchasing a painting by Monet, Monet is my favorite artist, so some of Monet's paintings are not even available for purchase. If one was, it would cost $100 million. So if you were able to contract for the purchase of one of Monet's paintings and it doesn't get delivered, you could go to court and ask for specific performance, because you could say, look, judge, there's no other piece of art that can replace a Monet. A Monet is what I contracted for. It's what I bargained for. It's what I was promised. And a Monet was not delivered. Some fakey art was delivered instead. I do not want counterfeit artwork. I want the Monet that I contracted for. In that instance, the court could order specific performance, and that would be enforceable by contempt of court and someone going to jail until they hand over the artwork. That's UCC 2-716, specific performance. A contract for the sale of land would not be covered by the UCC, but certainly that could also be enforced by specific performance, because if you agree to purchase a particular parcel of land, land is rare and it's getting more expensive than ever to buy. If you contract to purchase a piece of land and you decide you want a piece of land on the lake to build a house for yourself and your family, and the seller refuses to sell you the house after you've contracted for it and closed on the deal, you can go to court and ask for specific performance, because land is also rare. You can ask the judge to enter a decree forcing the seller to follow and perform under the contract. If they don't do it, they can go to jail for contempt of court. So that's a good remedy, specific performance. The UCC provides the buyer with the right to cover. Cover simply means that the buyer may obtain substitute goods from another seller. I mean, look, if you're the general contractor on a construction project and the person who is supposed to be supplying you pipes, if that company goes out of business, are you going to cancel the whole construction project? What would you do, Corinne? You're the owner or the general contractor on a construction project and you have to build a brand new elementary school, and the business that is supposed to be selling you pipes files for bankruptcy. Are you going to just quit the whole project? What would you do, Corinne?
Um, I mean, yeah, I guess if you're not going to get paid for it, you wouldn't complete it. I get, but it would just depend on the contract, on what you had agreed to, I guess.
Okay, well, let's assume in this scenario, Corinne, that I'm a contractor and my job is to build an elementary school. And I have subcontracted with a pipe supplier, and that company goes out of business. How can I still get my pipes?
Oh, I see. I misunderstood you. Okay. But yeah, I mean, you can search for a different company that would be able to get those pipes for you.
Good. That's the buyer's remedy under the UCC, and that's called covering. You've heard people use covering in a variety of situations, and that's it. You cover. That way you've got substitute goods and you can still complete your contract. You can get the work done. It's like if I needed to buy 500 pencils and Walmart is sold out, am I going to go without pencils? No, I'm going to go over to Target. And if they're sold out, then I'm going to go to Staples. And then if they're sold out, I'm going to go to whatever. You're going to find substitute goods from another seller until you get what you need to complete the project. That's covering. And suppose, Corinne, that when I buy the pipes, that that the alternate seller charges twice as much money for the pipes. What do I do then?
I mean, if that's, I, I guess in my opinion, I mean, if that's the product that you need, you kind of have to pay that price. But at the same time, I think you would then, if the other seller had filed bankruptcy, I guess I would probably file something to get, some type of damage or get paid potentially through the bankruptcy for, having to go with a more expensive seller and or just the time lost and all of those things. But you can definitely file a claim, of course, to be paid through a bankruptcy. So
Good, good, absolutely. And suppose seller number one doesn't really file bankruptcy. They just keep doing business, but they're not doing business with you. You can certainly sue for money damages. Suing for money damages would allow you to recover the difference between the cheap price that you contracted to pay for the pipes and what you actually paid. That difference would be your damages, and you could sue the breaching seller for damages. So good. That's exactly right, Corinne. And if the seller breaches the contract, the buyer can also cancel the contract. Here's a chart that explains it and summarizes it extremely well. And I think you could use this to do your Module 2 written assignment, which asks about remedies. I think you can use this chart also when you're studying for the quiz next week. So, situation, seller refuses to deliver the goods or delivers non-conforming goods that the buyer does not want. What's the remedy? Well, reject non-conforming goods, revoke acceptance, cover, sue for breach of contract, and get damages, or cancel the contract. So that summarizes what we just said, doesn't it, Jody? In the second situation, yes, the seller tenders non-conforming goods and the buyer accepts them. What can the buyer do? Sue for damages, deduct damages from the unpaid purchase price. Seller refuses to deliver the goods that the buyer wants. Sue for specific performance if the item is rare, like rare coins, rare artwork, something that's custom made. Sue for specific performance, and that means you have to go to court and get an order telling the seller to hand over the goods. And if the seller disobeys the court order, that's contempt of court and somebody's going to jail. Replevy is an action to recover goods. 3, recover the goods from an insolvent seller. And so, again, after the live session, be sure to review the UCC rules 2-716. Don't worry about Article 2A, which applies to leases. Just look at the UCC rules for the sale of goods. 2-716, 2-502, 2-601. Those are the buyer's remedies. Okay, let's get to our Module 2 assignment. It's all about remedies. Consider a scenario where the buyer and seller have a master contract that is complete and enforceable. 20 customized parts have been ordered from the seller by the buyer. Price is $1,000 a part. Custom made with painted advertising for the buyers. Only 20 parts have been shipped to the buyer, but the buyer rejects 10 of them and accepts 10. Buyer doesn't pay for any of the parts. So right here, Jody, what does the seller need to do? The seller ships 20 parts to the buyer. 10 are rejected, 10 are accepted. The buyer doesn't pay. What are the seller's remedies right here?
Not to ship any more, and then pursue a legal action for cover those revenues that they lost.
Yes. One other thing is ship conforming goods, cure. The seller has the right to cure because 10 have been rejected. So the seller has a right to cure the 10 defective goods by sending 10 conforming advertisements. And like you said, sue for breach of contract because the buyer accepts 10 but doesn't pay for them. Okay, so let's keep going with our factual scenario in your Module 2 written assignment. It says that the buyer held all the parts for 10 days, then returned the 10 rejected parts with a message that says they're too big, and the buyer intends to use the good ones and obtain cover for the other 10 parts from a different company. Seller has the full right to cure any defect, like we just said, within 10 days of notification of the defect to the seller. That's in the contract. And the return of the defective parts if the seller does not cure within 10 days. Then the buyer can obtain cover from another source. This paragraph in the contract is not intended to change any UCC remedies other than give time limits. So here are your 3 questions. Define cover and cure in your own words. We just talked about what they are. In the contract, in the context of this contract. So define what cover means in your own words, what cure means in your own words, and then cite to the UCC section. Next, complete the italicized portions of the partially completed IRAC table. Use the scenario, the UCC, and the contract to complete the table. And then finally, fix clause 3 of the master contract using your own words to improve the language. Explain why you made the fix. Let's look at part 2, which is IRAC. Iraq is opposed to Iraq, which is the country in the Middle East. Everyone clear on the difference between that? Iraq is a country in the Middle East. We're going to be dealing with IRAC, which is an acronym for Issue, Rule, Analysis, and Conclusion. So IRAC is an acronym. The use of IRAC is popular among judges, attorneys, paralegals, law students. It's a way to show application and analysis in a clear way. You first begin by reading the facts, which we just read, and determine the issue. Complete research to determine the applicable rule, or the UCC provision in our case. And the next step is the analysis. That's the third step. Apply the rule to the facts of the case. You may find the rule works. You may find the rule doesn't work. If it doesn't work, state that in your analysis. Try a new IRAC with a good rule that does apply. If there are missing facts, you should type that into your application and analysis. Indicate what facts still need to be sought and discovered. Conclusion is the last step in the IRAC analysis. Draw a conclusion based on your analysis, which is simply an answer to that initial issue question. So this wraps up the whole method. Issue, rule, analysis. That conclusion is to answer the issue question. So let's take a look at the form that's been provided in the written assignment. Let me see if I can share that file with you. I downloaded that earlier. IRAC table. Okay, so this is the IRAC table that you need to download for Module 2. It's a Word document, and the issue is already provided to you. The first issue is it legal under the UCC for Daniels to offer to cure the shipment? So that would be, in this case, that would be the seller. Is it legal under the UCC to offer to cure the shipment? Paraphrase the UCC section from your state's version of the code and cite the code section here. If you don't see your state's version of the UCC, just cite the UCC code. Application. If careful seller cures the shipment, the buyer would have 20 parts that are conforming. So what would be the conclusion in that example, Corinne? We're doing an IRAC analysis of that last scenario. If the seller provides 10 more conforming parts, then the buyer would have 20 parts that are conforming, all in accordance with the contract. So what would the outcome be? What would the buyer have to do? What do you think, Stephanie? What's your conclusion in this first IRAC analysis? If the seller cures the shipment by providing 10 more items that conform, then the buyer has a perfect shipment, a perfect tender of delivery. Okay, Stephanie's typed in the chat box. They would have to, hi Tina, let me open up my chat. They would have to abide by the terms of the contract. And what does the contract say the buyer has to do? What does the UCC say the buyer has to do? In layperson's terms, what does the buyer have to do? There you go, Adrian, Stephanie. Pay. It's very simple. If the seller delivers 20 parts in accordance with the contract that are conforming under the UCC and under the contract and under the common law, the buyer has to pay. So that's how you do IRAC. Let's look at the next issue. If a seller fails to cure the shipment in time, is the buyer entitled to buy cover goods from a competitor supplier? What do you think, Adrian?
Well, if they don't cure it within the time, then they don't have to pay for it. And then they could buy from another seller. But they didn't. I know I have another issue with this because they waited 10 days to tell them. So it's like, do they really have to conform? And you know what I mean? Anyway, that's another question for later. But
I think 10 days is a reasonable time.
But they waited to the 10th day. So is that, and did they, I have to read it again, but did they send it back on the 10th day? You know, because if they're sending it back, if they're sending the non-conforming parts back, they're not going to receive it within the 10 days. I guess they complained within the time frame, but still, that's kind of crappy that they waited that long. But whatever.
Yeah.
But anyway, yes, they would be able to go and buy from another seller, and the buyer would not have to pay for the non-conforming parts. So sorry.
Yes.
That was a long answer.
No, that's not a long answer. That's a good answer. The issue with the time, the law assumes reasonableness. 10 days is reasonable, and I think 10 days is what the contract says. So under the UCC, there's no time limit. The contract says 10 days. So the seller would have 10 days upon receiving notice. I think a judge would say, right? A judge, being a reasonable person, would say, okay, well, you've got 10 days from the time you receive notice to cover. I'm sorry, you've got 10 days from the time you receive notice of the non-conforming goods to cure the defect. So if the seller does not cure within 10 days of receiving notice from the buyer of the defect, then the seller's in breach of the contract. So I think the 10 days would start to run at the time the seller receives notice that the goods are non-conforming. Adrian, does that make sense?
Yes.
Yeah, it's a good point. So again, it says use and cite a state commercial code provision. All 50 states have adopted the Uniform Commercial Code, so you can look up the Minnesota UCC provision and cite to it. And this is saying, and find a case on the issue. If you get on Fast Case or Lexis Advance, go under Minnesota, you will be able to find the UCC provision and the case on the issue. And that's what this IRAC chart is asking you to do. Based on the statute and the case you found, how do you think a judge would apply the UCC section? And again, what's your conclusion in this scenario, Stephanie? Is the buyer entitled to buy cover goods from a competitor? Anyone else have any thoughts on that, Corinne? Yes, if the seller does not cure within 10 days of receiving notice of the defect, then the buyer is entitled to purchase cover goods from a competitor. So that's your conclusion. So once you learn how to do IRAC, it's very logical. And the final question, do a search for measure of damages for breach of contract, use Fast Case or Lexis Advance. So sort for the most recent case. When you are doing legal research, you do not want to cite to a case from the last century. That would be the 1900s. You want to cite to something that's current. Why? Because the law changes over time. You want to cite to something that's current because it has a much more chance of being applicable and not overruled. If the only case you could find was from 1972, you would want to shepherdize that case on Lexis Advance and look for any subsequent citations, because a case that was opinion that came out in 1972, there should be 50 years of subsequent history citing to that case. That case could be overruled, right? For example, there were cases in the last century that said gay marriage is illegal. All of that's been overruled because the Supreme Court now says gay marriage is legal. So anything, any of that old stuff is not applicable, should not be cited to. So that's why it says use the most recent case that you find that's on point. Use IRAC to analyze the main legal issue in the case, which is the availability in the case that you find. Cite the case using the Blue Book. What damages could be awarded in court according to the case that you find? How might this apply to the seller's case? How might it not be applicable in your conclusion? So this is asking you to do your own IRAC based on a case that you find, a scenario that you find, a fact pattern that you find. When you do this search, measure of damages for breach of contract. And so any questions? Yes. Stephanie says, what's the measure of damages? It's the amount that the affected party, the injured party, can recover for breach of contract. Good question.
Do you want us to just use the template for this part, or are we just making up our own for the IRAC?
No, use this template right here. It's perfect.
Okay, so we just are writing part of its paper and part of the template. Okay.
Yeah, for the second question in the assignment, you should use this template right here. These boxes might be bigger for this particular issue because you will be citing the case using the Indigo Blue Book. But this is going to be fun. I really look forward to finding out what kind of cases that you find. Cases from this century. Nothing from the 1900s. That's over. All right, let's get back to our live session presentation. Okay, great. So complete an IRAC analysis using the form provided in the Module 2 written assignment. Download the form, fill in the applicable UCC rule, and add your conclusion. Okay, you want to make sure that you read all of the lesson notes for Module 2. So let me go into the live classroom in the last 12 minutes that we have and take a look at what's going on in the lesson plan. Blackboard. Log in. It's amazing. I can remember all these passwords. So many. So many. The lesson notes are so very helpful, and the lesson notes will be very helpful in studying and preparing you for the Module 3 quiz. So we looked at the IRAC. Now we want to look at contract remedies for business cases. And what makes this fun is that you have some questions. We want to start. Okay. Select a topic to learn more. UCC code terms. All right. Select each tab for more information about terms used in the UCC code. So this is kind of a flashcard right here, Adrian. Cover. SCORM is probably some GUI. GUI is a graphical user interface. You don't need to worry about it, but I'm assuming that SCORM is a computer software program that we're interacting with when we do this particular exercise where we look at these terms. I think that's what SCORM is. It's a software interface. It's something techie. Okay, so this is like a flashcard. Specific performance, getting goods rather than money, repudiation, officially notifying the other party to a contract that the party will not fulfill the remainder of the contract, cure, to fix a supplied product or replace it with conforming goods, resale. This is one of the seller's remedies, to sell to another company that's not part of the contract. So if the buyer repudiates the contract before the seller delivers, the seller can resale the goods to another company. So this is like flashcards. What are your remedies in business cases? Money damages. If the seller gets a defective product, they can get damages. Pursue money damages. Remedies to resolve contract disputes. We just talked about that. Okay, let's do our knowledge check. Can everyone see this? The question is to buy the same product from a different supplier. What's the word that matches up with that? You can type it in the chat box. Adrian got it. Corinne got it. Tina got it. Yes. To buy the same product from a different supplier is to cover. Yay! Okay. When the seller fixes a supplied product or replaces it with conforming goods. Stephanie says cure. Adrian says cure. Tina says cure. Jody says cure. Let's see if you're right. I did select an answer. Look at this. Wow, it's all freezing up. But yes, that is the correct answer. I don't know what SCORM is doing. Come on, SCORM. Look at that. Select an answer before you hit submit. It's all freezing up. Aw, this was fun. How dare you freeze up like that?
You know what? It froze up on me the other day when I tried it, and I had to get out and wait for a while. So,
Yep, technology's not perfect, Adrian. It glitches. And it's glitching due to bandwidth. To buy the same product from a different supplier. Okay. To replace it. Okay, all right. Okay, so a product is correct and it fits the contract specifications. What's the term for that? If the buyer, okay, Adrian says conforming. Stephanie says conforming. Tina says conforming. It must be conforming. A product that is correct and fits the contract specifications. All right. Okay, a product is not the same item or items that were to be delivered under the contract. A product, the seller delivers a product that's not the same. Stephanie says non-conforming. Adrian says non-conforming. Tina says non-conforming. Corinne says non-conforming. Jody says non-conforming. You're right. Officially notifying the other party to a contract that the party will not fulfill the remainder of the contract. One party to the contract in advance notifies the other party to the contract that they will not fulfill the remainder of the contract. That is repudiation. Yay! Corinne got it. Stephanie got it. Everybody got it. Selling to another company that is not part of the contract. This is one of the seller's remedies in the event the buyer breaches. Selling to another company that is not part of the contract. Resale, yes, resale. It's like selling again, right? Selling again. Sometimes if you break down a word to its basis, the basic term of resale is what? Sell. What does it mean to sell again? Well, resale, right? Selling to another company that's not part of the contract, sell it again, right? That's like a rerun, a repeat, a resale. All right. Getting the goods rather than money compensation. In the event that a seller breaches a contract for the delivery of very rare and special goods, the buyer would need to go to court and ask for getting the goods rather than money compensation in the event of a breach of contract. Because maybe the contract is to sell a very rare piece of art, like a Monet painting. And specific performance, Stephanie got it. Yes, you would go to court and ask for specific performance. And even a lot of lawyers don't know that term, so good job. There's only one term left. Obtaining a court order to get possession of one or two or more items of personal property. And this could even occur outside of the contract action if your roommate moves out of the house and takes your cell phone with her, takes your microwave with her, takes your laptop with her. If your husband moves out of the house and takes your laser printer, you could file an action for replevin to recover your property. Replevin, obtaining a court order to get possession of your personal property. All right, so good. We got 100. So the only thing that you'll need to do is take a few moments on your own and work on your grammar. Grammar is very important. I'm going to show you the secret for how to easily manage your reading, and it is by using speech recognition. Does everybody know what speech recognition is on your computer? Yes, sometimes when your eyes get tired, but you're still a college student who has to read, you can use speech recognition. You would simply right-click on this and have it read it aloud to you, which for some reason it's not letting me do right now. But you can read your textbook aloud by highlighting on the particular provision and then right-clicking it and selecting read aloud. It won't let me do that because I'm within this context. So I always recommend that to students, that you can do it in the textbook also. Try the read aloud function. You can lay in bed and have this information read aloud to you. When your eyes get tired, it is a lot easier. Okay, well, this brings us to the end of our Module 2 live session. Be sure to read those lesson notes on your own. Use the read aloud function if you'd like to hear it. And that's all, folks. So this is a graded live session, which means you need to submit the correct answer to the live session question. The live session question is, what does UCC section 2-702 say? I'm going to type this in the chat box. You need to submit that answer by Sunday, and I know Adrian has to go. So your live session question for Module 2 is, what does UCC 2-712 say? You can probably Google it and find the answer. You can get the answer from your textbook. Just in the live session Dropbox, give me the answer for that question. What does UCC 2-712 say? Please submit the correct answer by Sunday, July 18th. Your Module 2 written assignment is also due Sunday, July 18th. If you have any questions or concerns, feel free to reach out to me by email or text message. I know, Jody, sometimes if you email me on a Saturday, I may not be looking at the computer on a Saturday. So if I don't answer your email fast enough, just send me a text message and then I will definitely be able to see what's on my phone. You know, when you're emailing stuff, you have to wait for the Microsoft Exchange server. And sometimes I just don't get the email till the next day, because sometimes on the weekend, I'm not doing schoolwork. So if I don't answer that email fast enough for you to submit your assignment, just send me a text message. But I will try to make every effort to respond to your email in 24 hours. But if you need an answer right now, I'm always looking at my cell phone. So just send me a text message and I will, give you the answer that way. You can always get anybody faster with the text message. So thank you so much. And I hope I was able to answer that question, Jody. And any other questions or concerns before we wrap up? Thank you, everyone, for taking the time out of your busy schedule to attend the Module 2 live session. And I am willing to stay here after to answer any questions or concerns that you might have.